Maharashtra Public Service Commission Rajyaseva Prelims exam is about to be conducted on this Sunday, 28 September 2025. We did the previous year question analysis of question papers of 2021, 22, 23 and 24, but those were in Marathi. So the students were requesting it the same in English. So we did an initiative and did the same for 2021 paper, and the response was really good, and students were asking for the next 2022, 2023, 2024 and question paper analysis in English. So here we are with the series of year 2022 question paper analysis of polity section. Let's have a look at the questions that were asked in the polity section of year 2022. The question that was asked were between 71 to 85. The 15 questions were there for the polity question, polity subject. The question first in the polity section is: consider the following provisions with respect to the National Commissions of India. Which of the above are correct? So let's mark here the correct has been asked. So we can remember the correct statements we have to register in our mind. First statement: National Commission for Scheduled Caste (NCSC) and NCST was established under Article 339 of the Constitution of India. Okay. The National Commission for Women was established under the National Commission for Women Act in 1990. Let's mark the act and the year, that is important. The National Commission for Minorities was established under the National Commission of Minorities Act 1992. On 27 December 1993, an ordinance was passed to establish the National Human Rights Commission (NHRC), and the date here has been given NHRC. So let's have a look at all these facts, and the correct answer has been asked. The B and C are the correct answers. A and D are wrong. So the B and C option is in the option number 4. Option number 4 stands correct. Why A and D are wrong? Let's have a look. A claims that the National Commission for Scheduled Caste and Scheduled Tribes was established under Article 339, but as we know, it is Article 338. And when the National Commission for Scheduled Commission and National Commission for Scheduled Tribes were separated, the National Commission for Scheduled Tribes was given Article 338A. The NCST is now 338A, and NCSC has been 338 always. So the 339 is the wrong answer. Let's have a look at the statement D. It claims that on 27 December 1993, the ordinance was passed, but the date is wrong. The 27 1993, yes, it was the year 1993, but 27 December was not the right date, so it is incorrect. So the factually B and C are the correct options, the correct statements. Option number 2. Let's have a look at next question. Delhi was called National Capital Territory, as we know, Delhi NCT we call it, by which Constitutional Amendment Act? So as we know, it was the 69th Constitutional Amendment Act that we know Delhi as Delhi NCT. It was done in the year 1991. Inserted the Article 239AA and 239B into the Constitution, providing a legislative assembly and legislative council for ministers of Delhi. Next question: which of the following statements are correct? Correct has been asked, so let's mark correct here. Regarding the citizenship of India, three statements are there. India has single citizenship system. B, Citizenship Act was passed in 1955, and C, Part 4 of Indian Constitution provides citizens. So the correct statement has been asked. So the statement A and B stands correct. C is wrong. So only A and B are correct. Option number 3. The statement C states wrong, because the Part 4 of the Indian Constitution provide citizenship. This statement is incorrect because Part 2 of the Indian Constitution deals with the citizenship. Part 2, not the Part 4. Part 4 deals with the DPSP, Directive Principles of State Policy. Next question asked is about Contingency Fund of India is placed at disposal of which authority among the following? The very right answer is President of India. The options other given as Comptroller and Auditor General, CAG, Parliament or Prime Minister. As we know, if we have studied the President topic, the disposal of contingency fund is within the financial powers of the President. So the right answer here stands is very straightforward question, President of India. Next question: consider the following statements regarding Keshavananda Bharati case. The 4 statements have been given, and which are the correct has been asked. So let's mark correct here, and we have to remember the correct statements. This case was heard by the Constitution Bench of 13 judges headed by Chief Justice of India A. N. Ray. In 7-6 majority, the bench outlined the basic structure doctrine. And C, this case changed the decision of Golaknath case. And statement D, this case seems to be instance of judicial activism. And which statements have been correct is asked. So the B statement, C statement, and D statement are correct. A statement where they are mentioning the Chief Justice name A and Ray is not right. It is wrong because Sikri was the Chief Justice head. S.M. Sikri was the head in this case. So the A statement stands wrong. So B, C, and D statement number option number 2 is correct answer. Let's have a look at next question. Consider the following statements regarding constitutional amendments in India and choose the correct options. 4 statements have been given. Dadra and Nagar Haveli territories were included in India as per the 10th Amendment. The territories of Diu, Daman and Goa were included in India in as per 11th Amendment. Let's mark this factual data. Legislative The legislature was established in Union territories as per the 15th Amendment, and the state of Meghalaya was created as per the 22nd Amendment. There are 4 places of name union territories and legislature, and the amendment number have been given, and which of the correct has been asked. So if we have studied, A and D stands correct, B and C are wrong, A and D correct. That's why option number 4. The B says that the territories of Diu, Daman and Goa were included in India as per the 11th Amendment, which is wrong. It is incorrect. The 12th Constitutional Amendment of 1962, not the 11th, but the 12th was integrated for Goa, Daman and Diu integration into Indian Union, while 11th Amendment, which was mentioned in the statement, is related to the election of Vice President. Remember this fact. The statement C says the legislature was established in union territories as per the 15th Amendment, which is again wrong. Why? The 14th Constitutional Amendment Act of 1962 provided for the creation of legislatures and councils of ministers for certain union territories. Meanwhile, the 15th Constitutional Amendment is related to high courts and not about these legislatures. Remember this factual data. It will be helpful for the next year's questions. Which article of the Constitution India provides for the post of CAG, Comptroller and Auditor General of India? A very straightforward question which should not take even 1 or 2 seconds to answer us. Article 148 is about related to CAG. Article 148 of Indian Constitution specifically provides for the establishment of the independent office of Comptroller and Auditor General of India. It outlines the appointment, oath, and conditions of service for the CAG, who is the head of the Indian Audit and Accounts Department and the Supreme Audit Institution of India. Next question is, the Indian Constitution establishes a secular state, meaning by which of these statements? 5 statements have been given, and which of the correct has been asked. The state makes discrimination on the basis of religion in matters of employment. This is a clearly a false and shocking statement which stands to be false. The state avoids preferential treatment for any particular religion. The state treats all religions equally. True. Freedom of faith and worship is allowed to all of the people. That statement also stands true. And educational institutions without exception are free to impart religious instruction, which is not 100% true or partially true statement because there are some exceptions. So A and E stands incorrect. B, C, and D are correct. So let's have a look where B, C, and D are mentioned. Option number 2, B, C, and D is the correct answer, are the correct statements. That makes our state, our nation, the Indian Constitution establishes a secular state by 3 of these given statements. The next question, which articles in Indian Constitution provide for the electoral system in India? Which articles are related to election? The question was asked, and as we know, if we have studied really well and have revised this topic, Article 324 to Article 329 provides for the election topic for the electoral system in India. So the right answer is 324 to 329. Consider the following statements about first Lok Sabha. 4 statements have been given. There is a lot of actual data, but as we know, in the very few initial lectures, we have did this topic and we have studied this very thoroughly and very deeply. Let's have a look at these four statements. The first Lok Sabha was constituted on 17th April 1952 after India's first general elections. Let's mark this factual data so we can have a look at it. After India's first general elections were held from 25th October 1951 to 21st February 1952, the first session of the first Lok Sabha commenced on 13 May 1952. The first Lok Sabha lasted its full tenure and dissolved on 1st April 1957. Shri G.V. Mavlankar was the first Deputy Speaker of the first Lok Sabha. Let's mark his name, let's mark his post, and let's mark the Lok Sabha number. And which of the statements are correct has been asked. So which statements are correct? As we know, A is correct. 25th October 1951 to 21st February 1952 was the time period when our first general elections were conducted, and it was constituted on 17th April 1952 is also correct data. The first session of the Lok Sabha commenced on 13 May 1952. That is also correct. That also stands true. As we know, we have studied this in a very initial lectures of us. The first Lok Sabha lasted full tenure dissolved on 1 April 1957 stands a little wrong. And Shri G.V. Mavlankar was the first deputy speaker. No, he was not the first deputy. In fact, he was the first speaker of first Lok Sabha, not the deputy speaker. So that's why this statement also stands incorrect. So only A and B are correct, which is option number 2, A and B correct answers. Next question, who among the following are members of a committee that recommends the appointment of CIC, Chief Information Commission, Mukhya Mahiti Ayukta? Who are the committee members? Prime Minister, Leader of Opposition in Lok Sabha, Leader of Opposition in Rajya Sabha, Union Cabinet Minister nominated by PM, and Speaker of Lok Sabha. These 5 people have been named given, and who are the part of committee that recommends the appointment of Chief Information Commission. So as we know, the Leader of Opposition in Rajya Sabha has no role into it, and also the Speaker of Lok Sabha have no role into it. Prime Minister, Leader of Opposition, and Union Cabinet Minister nominated by PM are the 3 people who form a committee to recommend the name of this CIC, Chief Information Commission. Prime Minister is the chairperson of this committee, and these 3 people recommend the name for Chief Information Commissioner, Mukhya Mahiti Ayukta. So the correct option is option number A, B, and D. Option number 1, A, B, D. Next question, the Central Information Commission includes 1 Chief Commissioner and maximum number of how many information commissioners? If we have a look at it, how important that topic had become in the year 2022, and that's why so many questions, the consecutive 2 questions was asked on the Information Commission of India. The Central Information Commission includes 1 chief, 1 CIC plus maximum number of how many commissioners? The answer is 10. Maximum 10 information commissioners can be appointed with the Chief Information Commissioner in the Information Commission of India, which is by RTI Act. Next question, identify the incorrect pair. There are some dates have been given and some historic events have been given on part A and side B. 22 July 1947, and it has given adoption of national flag by Constituent Assembly. Okay, that stands true because as we know, 22 July each year is celebrated as Rashtriya Jhanda Divas, National Flag Day, because the adoption of national flag was done by Constituent Assembly on this 22nd of July in the year 1947. So yeah, that pair stands correct, and we have to find out incorrect pair. This first one is correct. Second one is January 24, 1950, adoption of national anthem by Constituent Assembly. Yes, this one also stands true. 24 January 1950 was the last day when the Constituent Assembly appeared as a members and they did a meeting. That was the last day of Constituent Assembly of meeting. 25 January 1950, adoption of national calendar by government. This stands incorrect. January 26, 1950, adoption of national emblem by the government. The national emblem, the Ashoka Chakra and the lions, as we know. So this also stands correct. Why option 3 is incorrect? Because I have already taught this in our lecture that 24 January was the last day of Constituent Assembly's meeting. 25th January was the off day where they did not had any kind of meeting that day. And to remember this fact, I gave a logic in the pure practical basis that they might have decided in that way that 26th January is an important day for us. We will be accepting our constitution on that day and we will be presenting it to the nation, and we have been doing these meetings and all these since many last years. The Constituent Assembly were meeting for many frequent months and days, and the years have been passed. So let's have a one day of off, let's have a one day of rest on 25th. They must have decided it is on 24th, and so 25th day was off. The 25th January they did not have any meeting. So if they did not have a meeting, then having anything and getting accepted stands incorrect. So that's why the option number 3 is incorrect pair. Next question, match the following statement we have seen. Now it has been asked statements, correct one has been asked. You have to look out the Bombay case reference about these statements, and we have to see which are the correct statements. 4 statements have been given. The Bombay case judgment was delivered by the Supreme Court in 1994. States can appeal to Supreme Court when precedent rule is introduced in the states. If precedent rule is imposed without valid reason, Supreme Court can quash the decision of the central government. And statement D, an order to dissolve a state assembly requires the approval of the parliament. These 4 statements were given, and which of the correct has been asked. As we know, the data facts in given all the 4 statements said correct. It was done by Supreme Court in 1994. Yes, true. Appeal can be done to Supreme Court when precedent rule is introduced in the state. That also stands true. If precedent rule is imposed without valid reason, then the Supreme Court can quash, interfere. Yes, that also stands true. In order to dissolve state assembly requires approval of parliament. That also stands true. So A, B, C, D options are given in the option number 2. Right answer is option number 2, A, B, C, and D. Next question, which article empowers the High Courts to issue directions to the for the enforcement of fundamental rights? मूलभूत हक्क मौलिक अधिकार के directions के enforcement के लिए which of the article is empowered? So article 226 is the right answer. Article 226 empowers the court, the high courts, for the directions of enforcement of it. But let's not neglect the other options given. We shall have a look at article 135, article 143 and article 133. What are they related about and what they state? So that can be a next year's question. Article 135 is about jurisdiction of the Supreme Court transferred from federal court. All the powers and cases which were earlier under the federal court during the British rule were transferred to the Supreme Court after the commencement of the Constitution. Thus, the Supreme Court was vested with the same jurisdiction to maintain continuity. Article 143 is about advisory jurisdiction of Supreme Court. Means the President can ask for any advices from Supreme Court about some important topics, some sensitive topics, especially when the knowledge is required about the law, the deep knowledge requires about the law and the Constitution. At that time, Supreme Court gives it advisory opinion to the President, but that advice is not bound. The President is not bound to follow it. The President is not binding to follow. It is only advisory jurisdiction of the Supreme Court for President. Article 143. Article 133 is about civil appeals to the Supreme Court. In civil cases, appeals can be made to the Supreme Court against final judgments of high courts. Such appeals are allowed only if the case, remember, only if the case involves a substantial question of law of general importance. That is the statement given for Article 133. We had a look at article year 2022 previous year question paper of polity section. In next video, we will have a look at the year 2023 question paper and 2024 question. By that time, look at the other videos of other topics. Thank you.